Now our topic is going to be human rights. It is possible to begin talking about human rights by presenting a definition of human rights based on a three-part schema. Here we can say that human rights are high-ranking legal protections of the fundamental interests of every human being. This definition then has three components, one relating to legality, one relating to importance, and one relating to equality. We're going to look at each of these components in turn. As it happens, it's better to begin by discussing equality. Human rights are the rights of everyone, the rights that everybody has just by virtue of being human. In this manner, human rights are quite different from other rights you may find in the law. So the rights of contract law depend on my ability to first enter into a contract. No contract, no rights. The rights of property depend on my ability to acquire property. Historically, even constitutional rights were limited. For example, the rights under the Constitution may have been the rights of the French, the rights of the English, but not necessarily the rights of everyone. Today, constitutional rights are expanded to cover everyone, but this is not always the case. For example, some rights remain tied up to citizenship status. Human rights tries to be different. At least in theory, human rights are supposed to be the rights that every person has just by virtue of being human. No condition is put on your ability to have these rights. We all have them equally. Here it's opportune to give you an image of how these rights may be egalitarian. This is the image of the infant in the snow, presented for other purposes by Timothy Endicott. Endicott says, consider the scenario that you're walking by in a blizzard and you find an infant that has passed out and the infant is lying in the snow. That infant has at the moment no ability to reason, no ability to use language, no plans, goals, or objectives. Its capacities are feeble and flickering, even as he is in the danger of dying. However, we may say that from the perspective of human rights, the difference between that infant and a flourishing 20-year-old in the normal life of the city will be null. They all have the same access to rights. They all have the same basic human rights, or at least that's how it should be. The second consideration is that human rights is a set of fundamental entitlements. Human rights do not protect our ability to drink coffee, our ability to go for tourism, or our ability to have a resit exam if we fail the first exam. These things may be desirable, but they are outside the range and scope of human rights. Human rights protect our life and limb, protects our physical and mental integrity against torture, protects freedom of speech, the ability to have a conscience, the ability to worship or not worship according to that conscience, our ability to have these basic fundamental necessities like food and shelter. So in this way, human rights is characterized by Henry Shue as the morality of the depths. Human rights is not about the peaks to which human life may rise, with your ability to become a Goethe or an Aristotle. Human rights is about the depths to which human beings should not be allowed to fall. So it's not focused into the highest achievements that people may have, but rather it would focus normally into protecting catastrophic situations at the individual level. Finally, we have characterized human rights as being high legal protections or high-ranking legal protections. The idea of legal protection here refers to the idea that rights are sharp demands, demands that you must be allowed to do something, that others must be prohibited from doing something to you, or that others must be required to do something for you. For example, you must be allowed to have a religion, you must be protected, that is, others must be prohibited from torturing you, and others may be required, for example, to give you monetary assistance for hiring a lawyer so that you may have fair trial in a criminal case. So here we have sharp demands, commands and not counsels, requirements and not recommendations. This is quite characteristic of the idea of human rights being rights. And they are high legal protections. And the phrase high, I want to leave it a little bit vague for the moment because it needs to be unpacked in different ways in different legal systems. But the main idea is that human rights are not just one rule amongst other rules. They have a higher hierarchy, a higher precedence. So naturally, if the municipality makes a regulation that threatens your human rights should triumph. If the legislature, if Congress makes a legislation that trumps your human rights should triumph. If the EU makes a regulation or a directive that tramples human rights should triumph. So this is the idea that human rights are legal protections that are hierarchically superior. Maybe they are not superior to everything, that's why I'm being a little bit vague in what high means, but they are at least superior in ordinary circumstances to other legal considerations. There is one fourth element that according to some authors must be added to the three elements I gave you, and according to others it's not necessary. So now after giving you the three indubitable elements of human rights, I'm going to mention the fourth one and explain the polemic around it. This fourth element could be called something like autonomy or beneficiary control, and this is something rather technical. Essentially, the concept of autonomy or beneficiary control means that if you have a right to something, it's up to you, it is your choice, whether you enjoy the right or not. And then it's also your choice to waive the right or even to forfeit, to abandon the right. And this is quite natural if we think in the rights of, let's say, the civil law. If I am the owner of a piece of bread, I can enjoy the bread, but I can also discard it. I can also give it to somebody else. As the owner of a house, I have a right that the house is not subject to trespass, but I can allow people in. It's always up to me. It's always in my control whether that right gets used or not. And certainly, a lot of human rights do fulfill this requirement. For example, the right to freedom of religion is a freedom to have or not to have, to exercise or not to exercise a religion. The right to privacy is a right that I can waive. If I decide to allow people to read my personal diary, my privacy is something that I can give up, something that I can remove, and then allow others to enter into that realm. But there seems to be in the law a lot of rights that do not function like this. For example, the right to be free from torture is not one that typically would allow waivers or that gives you choices. The right to be free from torture is not giving you a choice to be tortured if you want to and not tortured if you do not want. It is simply a prohibition. It is just an absolute prohibition on certain forms of treatment, whether consensual or not. No waiver would make sense of a right like the freedom of torture. A little bit less, without going to those extremes, we could also mention the right to education. The right to education is one of the most well-recognized social rights, so rights that require, let's say, significant state action instead of just state inaction or forbearance. The right to education, which is recognized pretty much the world over, for children is not just a right, it's also an obligation. And people have no problem saying that education is a right, even though children who are the beneficiaries of this right cannot really say, well, I waive my right to have an education. I would rather stay outside in the park playing. So generally, we would say that some authors would say that this is a conceptual mistake. If you really want to think of human rights as rights, you must allow these waivers and these suspensions, these choices to have or not to have the right. Now, I think that's not a choice we need to make. I think we can simply say most human rights are waivable, but then some are not. And to explain the nature of these exceptions, it's not necessarily difficult because, of course, most of us will not want to live in a society where consensual torture is permitted. So human rights are very important, but they're not everything, and they also have to live together with other sorts of requirements. Now let's say that we get that out of the way and we discuss where do human rights come from. What is the origin of human rights? If people have human rights, what's behind that? Naturally, this will be an area where we explore the sources of law, in this case, the sources of human rights law. And that will tell us not much that is new. If you're thinking of the human rights that arise under international law, then we will say the sources are treaties or customary law. If we think that you could call constitutional rights also human rights, and I think that's a fair thing to say, then we would say, well, the source is the Constitution. And that would not lead us to many complications. We will just have to keep tabs of the different agreements that exist. For example, the European system of human rights, the Inter-American system, the UN system, or keep tabs to the different constitutional configurations, the very different, for example, system of protection of human rights in the German Constitution as opposed to the American one. But there is a further complication here for the field of human rights that is not true for other fields of law. Because if we say human rights exist because the state gives them to them, if we say, well, the sources, that's where it comes from, when states enact human rights in a treaty or lay it down in a constitution, we actually enter into a realm of paradox. Because the idea of human rights is that these rights are not something that states grant to us out of generosity, but something that belongs to human beings. Naturally, different states will grant different rights across different historical eras. If that's the whole of the story, then the idea that human rights are about equality simply cannot be cashed out. If we limit ourselves to the literal sources of law in treaties, customs, constitutions, we will have to say something like, well, North Koreans, well, they don't have human rights. Or slaves in the 18th century, in the 19th century, they did not have human rights. They only got human rights in the 20th century or in the late 19th century with the abolitionist movement. And again, there's an air of paradox here because the point of human rights is to say that human beings have them radically, that human beings are equal in this dimension radically, and that the state does not grant human rights, the state does not give human rights, the state only recognizes the rights that are already there. In exploring this distinction, we must then become able to differentiate two dimensions of human rights. Human rights as law and human rights as philosophy. And in this area of law, it's actually not possible to do one without the other because you enter into this paradoxical situation of breaching the requirements of equality for the sake of legal positivism. So the only way to defend the idea that human rights are really equal and for everybody is on the basis of thinking that the law does not exhaust their existence. They also have a philosophical dimension, which is what the law tries to recognize and enact. So then we may say from a philosophical perspective, the people in North Korea have human rights, notwithstanding their government's inability to recognize them. From a philosophical perspective, we would say that slavery and the slave trade was a grave, severe human rights violation, even when it was not yet legislated to be so. This is possibly the only way to think about this that makes sense. But we should not stop there. Human rights are legal rules. Human rights are a philosophical theory of the rights that inherently human beings have, but that's not all. We do not capture the whole of the phenomenon if we stop there. We must also see that human rights have become a special sort of politics. That is to say, human rights is also the story of the human rights movement, or maybe even better, human rights movements in plural. That is, of different groups of people, NGOs, politicians, states, that wish to achieve their aims by banding together under the idea, ideology, philosophy, brand, or banner of human rights. And this is something that is not captured either by the legality or by the morality or philosophy of human rights. This is something independent and special and increasingly possibly the most important dimension of human rights. So human rights is not simply some rules laid down, but it's also the basis of a political movement or a variety of political movements. And here we may see on the one end of the spectrum NGOs like Amnesty International, Human Rights Watch, and other NGOs that band together in alliances under the banner of human rights to achieve their aims, but also of governments and politicians that will talk about human rights as a way to justify their agendas. And that may include, for example, the agenda of President George W. Bush in expanding democracy in the Middle East, also in the name of human rights, or the agenda of the EU of passing sanctions against Russia because of its human rights record. The idea of seeing human rights as having a political dimension that goes beyond the rules and the morality of it is essentially in noticing its relative independence. When George Bush appealed to human rights in order to justify a war in the Middle East, we should not believe that that is because philosophically human rights support that, or because legally they support that. It's quite simply because the concept has its own ideological power, and it can be used, it can be wielded by those who want to achieve certain aims, whatever those aims may be, as a way to make it more likely that they will achieve their goal. It is said that the moment you talk about something as a matter of rights and you're able to present yourself as a victim of a human rights violation, in that moment, your claims become more powerful and more visible. And that allows both rightful claimants and less rightful claimants, to be able to present their grievances in this manner. And because of the nature of the society in which we live, that form of mobilization, that form of grouping together to achieve an aim under this schema of rights, victimhood, and claims is effective and powerful, at least for now. Beyond this legal dimension, this philosophical dimension, and the political dimension, we may want to add a fourth one, a novel dimension of human rights. This is just something that has developed in the last decades. And it is the idea that human rights can actually be a benchmark for measuring the performance of states and other organizations, but especially for states. And the idea here is related to the work of Amartya Sen and Martin Nussbaum relating to the capabilities approach. The idea is that instead of judging development, growth, and welfare of states through economic metrics such as GDP or GDP per capita, we would rather want to judge the wealth and development and the growth of states by their ability to increase human rights, by their ability to give real liberties and opportunities to their citizens. This is a novel project, I would say a very interesting project. Conceptually, it has a lot to be said for it. Say, well, what is what ultimately matters? What is what the economy and the policy of the state should be aiming to? With that may be easy to say that it's to a greater achievement of human freedom. So that it's actually a very interesting setup, and there is a wealth of empirical information growing every day that measures the state precisely around their human rights capabilities or human rights performances. Especially the Millennium Development Goals and now the Sustainable Development Goals are essentially this type of project. So if you see the MDGs and the SDGs, they literally do not always speak about human rights, but you could put them in a column and match them to human rights and say that their content is really very, very similar. So this is the idea that human rights could be more than just a legal norm, more than a political program. They could actually become a technical norm for measuring the growth of societies. Now let's address the issue of substance. What human rights do we have? An initial challenge here is that there will be really very many rights. In terms of the law, we may find that we have been granted some 40, 50 human rights, and it's rather difficult to count them. And then if we count them, it's difficult to present them one by one. In order to make the presentation analytically viable, the best thing we can do is to cluster these rights into different groups. Then we give an idea of what we find in each group, and you'll see that in this manner you will really come to have a grip onto what human rights there are. So first and foremost, we can talk about rights to integrity, that is, to your own physical integrity, mental and physical well-being, that is, to be protected from arbitrary killings, to be protected from torture. These rights are special because I think they are absolutely the most fundamental of all human rights. The moment arbitrary killing, the moment torture become possible, become options, then everything else that you may have at the level of human rights becomes simply superfluous. These rights to integrity are also important because their breach clearly constitutes not just a human rights violation, but it also constitutes a crime, most possibly even an international crime. So that's why I set this aside as a special. Later we will have freedom rights. Freedom rights are a cluster of rights that protect your autonomy against the state. These include freedom of speech, freedom of religion, freedom of conscience, freedom of association and assembly. These are the classical freedoms of the French Revolution and of the American Revolution that aim basically to create for individuals a sphere free from state autonomy. We may or may not want to include the right of property in this list. Third, we would have social rights. Social rights, by contrast to civil rights, do not aim to keep the state away from you, but rather to call the state to aid you when you need it. This includes rights to education, shelter, food, and water. These rights are historically later in their appearance. So after the French Revolution, after the American Revolution, and the creation of the liberal state, we have the development of the welfare state in Europe and expanding to the rest of the world. And with this new paradigm, it's not enough that the state would leave you alone. The state must also take actions to ensure a certain minimum level of well-being and welfare for the population. Later, we will have equality rights. We have said that human rights apply equally to everybody, and that's one thing. That's the most basic level in which human rights are equal. But beyond that, human rights also require equal treatment from the state in a wider basis, especially as it relates to stigmatizing characteristics, that is, potentially stigmatizing characteristics such as race, gender, ethnicity, or religion. That is the prohibition of discrimination, that the state in its actions should not create a class of preferred citizens and a class of second-class citizens, but rather should treat all citizens equally. And finally, we may find procedural human rights. And procedural human rights at this point in the story will be very easy for you to understand because they overlap with what we already discussed in procedural law and to a lesser extent in administrative law. They are the guarantees that exist in relation to the judicial process that a state may use against you. So to prevent the state from becoming tyrannical, the idea is that it is bounded by a judicial system where certain guarantees apply, such as fair trial, impartiality of judges, equality of arms, and the right to a public hearing. So all these rights are very important and they would go together on the idea of procedural rights. I do not mention other potential types of human rights, which include the alleged human rights of groups, and also the so-called third-generation human rights, such as the right to peace and the right to a healthy environment. I will not mention those because their inclusion is more polemical at the political level and at the philosophical level, and they would be left for more specialized courses. How are human rights enforced? Well, we must make a distinction between the judicial enforcement and the informal enforcement of human rights. This distinction is a very big and wide distinction. Judicial enforcement is something very specific and precise. Informal enforcement is everything else. And this is a good distinction to make, because judicial enforcement would be the ideal. The ideal scenario is that if your human rights are trampled, you go to a court and petition for redress, either a local court or an international court. The court assesses your case impartially, and then depending on what it finds, it grants you compensation or not. Naturally, because human rights protect the individual, and a trial is one in which your position as an individual is protected and magnified by the rules of fair trial, fair hearing, and equality of arms, these two things go together. The ideal scenario is that human rights are protected judicially. In a system where the judicial system works, you can expect judicial protection of human rights to be effective. It will work. So if you are living in the Netherlands, in Austria, in Norway, and your human rights are trampled, it is likely that the state will be able to solve your problem, and that if that doesn't work and you go to the European Court of Human Rights, for example, the decision of the European Court will be respected and enforced. But what happens in societies that are not so well organized, where the judicial system has not reached a level of independence and maturity that it can actually work impartially and command the authority of the government? Or what happens in the scenarios where judges simply are not available for them to give jurisdiction because the scenario happens outside the borders of the state, for example? Here is where you have to fall back to informal enforcement. And informal enforcement is really a very, very wide field. The idea here is that because human rights are a global moral concern, so they're just not just a legal concern, they're a moral concern, anybody can take up the task of criticizing a certain form of behavior as a human rights violation and mobilize whatever pressure he or she has to make sure that the problem is remedied. This mobilization is typically called naming and shaming. So simply, there is power still today in saying with credibility that a certain entity, a state, or actor has violated human rights. So this is a form of informal enforcement that is really open to anybody, ranging from states to other states trying to shame other states, or a person with a camera or a person with a blog. And then this form of informal enforcement is not something that can be avoided or forgotten, because if we would only rely on judicial enforcement, human rights would not be available in the situations when they're most needed, because it's precisely in those societies where the judicial system has not achieved respect and impartiality where the most severe human rights violations will arise, and where you will have the stronger need for some form of enforcement.